Hello, welcome to our data protection webinar, where we will discuss a recap of the data protection events in 2024 and provide an insight as to what we might expect from 2025. My name is Louise Keenan and I am an associate within the data protection and employment team. I'm here with my colleague, Shauna Jones, a trainee solicitor also in the data protection and employment team.
Hello. Yes, it's been a bit of a confusing time for data protection. In 2024, we had talk of a new Data Protection and Digital Information Bill, and then we had a change of government and talk of a new Data Use and Access Bill. So it's not surprising that many have been left not really understanding where we are now and what happens next, which is why we thought this webinar would be helpful.
So let's recap briefly on what happened in 2024. We had the Data Protection and Digital Information Bill presented to Parliament. The bill was intending to update and simplify the UK's data protection framework with a view to reducing burdens on organisations while maintaining high data protection standards. Some of the key provisions included limiting the definition of personal data by focusing on the knowledge of the controller or processor when looking at whether someone can be identified from the data, changing the threshold for charging a reasonable fee for a data subject access request or refusing to comply with a request completely from manifestly unfounded or excessive to vexatious or excessive. The idea being that this was going to be a lower threshold and would therefore catch more requests, so there'd be more chances for a data controller to refuse data subject access requests or charge a fee for complying with these. Allowing controllers to request further information to identify the personal data or processing activities when dealing with data subject access requests, which would effectively pause the time limit for responding until the information was provided, and that was reflective of ICO guidance in any event. Setting out a list of recognised legitimate interests, which would form a legal basis for processing, and removing the need for certain organisations to appoint an external data protection officer and to instead appoint an internal senior responsible person. However, we had a general election in 2024, and as usual, any bills which haven't made it through to law by the time Parliament is dissolved are abandoned. If the new government want to continue with these bills, then they have to reintroduce them and start the whole parliamentary process again.
That's right. And in the King's speech in July 2024, King Charles proposed that 2025 would see the introduction of a new bill instead, the Digital Information and Smart Data Bill. It was highlighted that this new Labour bill dealing with data protection would focus on ensuring data protection legislation in the UK was clear and of a high standard. By the time the bill was presented to Parliament in October 2025, it had been renamed as the Data Use and Access Bill, otherwise known as the DUA Bill, and this is now the bill that we currently have for data protection. The DUA Bill is similar to the old Data Protection and Digital Information Bill in many respects, but some of the more controversial provisions have been dropped. In particular, the more limited definition of personal data has been scrapped. The new vexatious or excessive threshold, which would have been used when looking at whether you could reject or charge a fee for a data subject access request, has not been taken forward. And there's no mention of replacing data protection officers with senior responsible persons in the DUA Bill. The DUA Bill is split into 8 parts. These parts are access to customer data and business data, digital verification services, National Underground Asset Register, Register of Births and Deaths, data protection and privacy, the Information Commissioner, plus 2 final parts dealing with other miscellaneous data protection provisions. Some of these parts will have more of an impact on the everyday use of data protection than others, particularly Part 5, which is dedicated to changing the UK GDPR and Data Protection Act 2018. As such, this is the part we will focus on in this webinar.
Yes, let's work through the key provisions of that part. Currently, the law allows the processing of personal data where this is in pursuit of the legitimate interests of the controller. and this requires the data controller to conduct a balancing exercise between the legitimate interests that it's pursuing and the fundamental rights and freedoms of the data subject. The Doer Bill contains a bit more clarity around this by setting out a list of examples of what could constitute legitimate interests, such as direct marketing, intra-group transmissions of personal data for internal administrative purposes, and processing to ensure the security of network and information systems. It's not an exhaustive list, and controllers wanting to rely on these will still be subject to the usual balancing test. The Doer Bill also, however, sets out a new lawful basis allowing data controllers to process personal data where it's necessary for the purposes of a recognised legitimate interest. And it sets out a list of recognised legitimate interests, which include disclosure to a person carrying out a public interest task, safeguarding national security, protecting public security, or defence purposes. In these cases, there's no need to carry out the usual balancing test, as they are recognised legitimate interests, and the list of recognised legitimate interests can be expanded by the Secretary of State via further regulations.
Yes, the Doer Bill also gives guidance on when personal data can be processed for further purposes other than those for which it was processed originally. The law currently says that personal data cannot be further processed in a manner that is incompatible with the original purposes. The Doer Bill sets out factors that are relevant in assessing whether a purpose is compatible, such as any link between the old and new purpose, the context in which data is collected, and the possible consequences of the processing. It also sets out circumstances where a purpose will be viewed as compatible, such as when the data subject consents to the new processing. The Doer Bill contains more powers for the Secretary of State to make further regulations, including to be able to add new special categories of personal data which attract greater protection. It also has provisions which provide for greater flexibility around processing for research, archiving, and statistical purposes.
Yeah, and there are also new provisions on automated decision making, which have the effect of relaxing the existing rules for personal data, though not for special category data. In practice, this means that businesses can use automated decision making more widely, which in the rise of AI will be an interesting development. The Doer Bill also clarifies certain aspects of data protection law by confirming existing case law or guidance in some areas. For example, the Doer Bill makes clear that data controllers responding to data subject access requests only have to carry out a reasonable and proportionate search for personal data, which is in line with current case law. It also makes clear that data subjects need to approach the data controller with their complaints before contacting the ICO, which is also in line with the ICO's current guidance. It further contains provisions about stopping the clock on response time for data access requests when the data controller reasonably requires further information to identify the information or processing activities. It says that an example of a case in which a controller may reasonably require further information is where the controller processes a large amount of information concerning the data subject. Again, this reflects current ICO guidance. Now, it doesn't mean that you can force a data subject to narrow down their request. It means that if you process a large amount of information and it's not clear what information the individual is requesting, you can ask the requester to provide additional details about that information that they want to receive, such as the context in which you may have processed their information and the likely dates of when you processed it. However, it's important to remember that they are still entitled to ask for all of the information that you hold on them. And if they continue to request this, data controllers must make a reasonable search for that information.
The Doer Bill introduces a new data protection test for the Secretary of State to apply when deciding whether to approve a transfer of data to another country. The Secretary of State will need to assess if the country has a standard of data protection which is not materially lower than that in the UK. It remains to be seen what this will entail exactly. There is also an increase to the fines available for breaches of the Privacy and Electronic Communications Regulations 2003, which cover areas like marketing and cookies, to match those applicable to a breach of the UK GDPR, namely up to £17.5 million, or in the case of an undertaking, up to 4% of the total worldwide annual turnover of the preceding financial year. It is also worth noting that Part 6 of the DUA Bill proposes changes to the Information Commissioner's Office, otherwise known as the ICO. The ICO will be replaced with a corporate body overseen by government known as the Information Commission. There are also some proposed changes to the way in which this Information Commission exercises its powers, which will give it more enforcement powers. For example, it could order a data controller to provide a report at the controller's own expense, and make an order requiring a data controller's staff to attend an interview and answer questions. The ICO has published a response to the draft bill, agreeing with its reforms and stating they believe it will enhance regulatory effectiveness. As the bill makes its way through Parliament, we expect further information will come out as to what we can expect from these changes and when they will be implemented.
Moving on now to one of the other big talking points in data protection in 2024, artificial intelligence, or AI. AI is being used increasingly in businesses. For example, many organisations use AI algorithms to analyse customer behaviours and to make personalised recommendations for them. There are AI-powered chatbots and virtual assistants, and AI can be used to assess large volumes of data to help in a variety of sectors, including health, manufacturing, and the automotive industries. Coming from an employment background, I've seen it used in recruitment, for example, to screen job applications, and it can also be used to measure things like employee engagement and employee performance. AI creates great opportunities for businesses, but unsurprisingly, it also raises concerns over data protection, as AI tools will usually process a large amount of personal data, including special category data, and often from a variety of sources. Some AI tools like chatbots extract data from various places on the internet, a process known as web scraping. The ICO has published guidance to assist organisations, which is really helpful for organisations to review. And this often sets out what the ICO regard as best practice with regard to AI. The ICO also launched a series of consultations in 2024 to determine how data protection legislation should deal with generative AI. As AI becomes more lifelike and has the potential to be abused, it's important for data protection legislation to keep up and ensure it provides protections in order to safeguard those involved.
Exactly. The ICO published 5 consultations throughout last year, and in December 2024, it published a report detailing the outcomes of those consultations. This ICO guidance has provided further advice on how developers train generative AI models, and provides that web scraping, the process we have mentioned, in which large amounts of data are automatically gathered from numerous websites, shouldn't be used. And if used, developers will need to demonstrate whether their use of such a method is necessary for their legitimate interests. There was also an emphasis regarding how systems should be designed to include safeguards to ensure data protection principles are being effectively implemented. In addition, there have been discussions in how legislation will be interpreted in order to safeguard against AI. Many aspects of this are of course too detailed and technical for us to go into today, but the ICO is always updating its guidance, which is worth reviewing, and it's planning to update its guidance further in light of the DUA provisions. Needless to say, it's an area where we are likely to see further guidance and updates in 2025. It's also important to mention that whilst we are focusing on the UK today, organisations that operate in the EU will need to bear in mind the EU Artificial Intelligence Act, which came into force on the 1st of August 2024. This act aimed to set out a uniform framework for the development, supply and use of AI systems. It assesses AI systems as falling within one of 4 risk categories, namely prohibited AI practices, high-risk AI systems, limited risk AI systems, and minimal or no-risk systems. rules for the AI systems will largely depend on the category of risk they fall within.
Yes, and this year we also expect to see the ICO maintain its focus on tackling data breaches and taking action against those who've breached their data protection obligations, which includes the imposition of monetary penalties. The ICO published these on their website for anyone wanting to have a look at them. Last month, there were 2 fines levied against organisations of £120,000 and £170,000, related to vast numbers of spam and unsolicited calls. In one case, over 168,000 spam calls were made, resulting in several complaints to the ICO, and the organisation involved didn't provide any evidence that individuals had consented to the calls. In the other case, the ICO found that an organisation had bombarded people with over 4 million unsolicited direct marketing calls to numbers that had been registered to the telephone preference service, meaning those individuals had already opted out of such calls and should not have been contacted. The ICO is also likely to continue its effort to enforce breaches of the Privacy and Electronic Communications Regulations 2003. These regulations contain specific rules on marketing calls, emails, texts and faxes, cookies and similar technologies, keeping communication services secure, and customer privacy as regards to traffic and location data, itemised billing, line identification and directory listings. As we've already mentioned, if the DUA bill becomes law, then fines for such breaches will be on a par with those available for breaches of the UK GDPR, which means we could see significant fines being levied against organisations. And so businesses may want to consider their practices now in this regard to ensure that they're compliant. Finally, we should mention that the UK's adequacy decision, which permits the transfer of personal data between the UK and the EU, runs until June 2025. And so we'll see in 2025 if the UK receives an extension to that decision. It is expected, however, that this will be extended and that the proposals in the DUA bill are not likely to jeopardise this.
So, 2025 could be a busy year for data protection, in particular with the legislative reform in the shape of the DUA bill. Parliamentary processes do take time, and so even if this law does come into effect, we might not see its provisions implemented this year, and it remains to be seen what secondary legislation will be enacted. As the DUA bill is largely based on the previous Data Protection and Digital Information Bill, which had progressed to the latter stages of the parliamentary process, it's expected that this DUA bill will proceed more rapidly. However, it's important to remember that the DUA bill may be amended as it makes its way through Parliament. Perhaps unsurprisingly, given it will want to retain its adequacy decision, the DUA bill is closely aligned to the EU. We will need to wait to see if the UK's adequacy decision is extended in 2025, though, as we've said, it's expected that this will be the case, allowing data to continue to be shared freely between the UK and EU. We do also expect there to be developments globally as technology and use of AI develops, and given the cross-border presence of how data exists online, this may encourage further changes to be made in the UK. The ICO continues to update its guidance on AI in line with its consultations and the changing landscape.
We will, of course, provide updates on data protection through Clark's Legal Insights page, so please do check in with this if you have any questions, and please do feel free to contact us. We also publish regular articles about how data protection is changing and provide helpful tips to businesses as to how they can best comply with their obligations. You can sign up to our mailing list if you'd like to receive any of these.
Thank you again for taking your time to watch our webinar.